Hello, everyone. Welcome to LAWS12070 on Public International Law and Human Rights Law. So welcome to the course. This is a different field of law, mainly because perhaps throughout most of your law's degree, you have been focusing on domestic legislation or domestic laws, whether you probably study contracts or family law or even constitutional law, administrative law or criminal law. You've often been dealing with municipal laws or laws pertaining to Australia. And in this specific course, our focus will no longer be so much on Australian law, but actually on what is known as public international law. And then we will also be examining the notion of international human rights law. And obviously the framework therefore is different because our focus is not so much on Australian laws, but public international law, which actually focuses on the relationships of states, as well as other subjects of international law, such as international organizations, as well as some of the transnational corporations, as we will later on see. Now, international law has actually become more relevant in the context of today's activities, mainly because of globalization, economic liberalization, and technological advances. So if you look at globalization, for example, much of today's states, and when we speak of states, we're talking of sovereign states. So you're talking of Australia, you're talking of New Zealand, you're talking of the United States of America, you're talking of Malaysia, you're talking of Indonesia. You're not talking of states which are constituent elements, for example, of the Australian Federation. So we're not talking of New South Wales. You're not talking of Queensland. You're talking, when we talk of states in the context of international law, it is always about sovereign states, which sometimes should be called nation states or sometimes are called countries. But in public international law, we refer to these sovereign states as states. And so going back to the idea of globalization, what that's actually happened is that a lot of states are now more interconnected. So if something happens, for example, in the United States, particularly because of changes in their monetary policies or as an effect of their national elections, it can have an effect on other states. If there is a recession in the United States, it can also have an effect on Australia. And if there are changes, for example, in political regimes, whether something is happening in Turkey or something is happening in Libya, there is a likelihood that it has an effect on other states as well. And that is because of the idea of globalization, where there is a strong interconnection of states, not only in terms of the economy, but even in terms of demographics, in terms of social interconnections, even in terms of cultural changes. And therefore, we know a great deal more about what is happening in other states than in the past. And this is primarily because of technological advances as well. So you speak of the effect of the internet, you have Facebook, you have Twitter, and you obviously have online news media, which enables every single person in most parts of the world to know what is going on in other parts of the world. Economic liberalization has also meant that the economies of most states are therefore interconnected, which means therefore, as I pointed out, if in terms of the global financial crisis in 2008 or the global financial crisis in 1997, it had a strong ripple effect across other states. And which means therefore that given the fact that there is so much interconnection among states today, we need to figure out if there is a problem, if there is an issue that evolves which has an international dimension, what laws or legal regime would then govern these issues? If there is a conflict between states, what laws will therefore govern these conflicts? And as we will later on see, it is international law which provides the regime of legal rules that governs the conduct and relations of sovereign states. Now, in addition, we will also see that there are a lot of global issues today which affect, therefore, the community of states. So if you talk about environmental degradation, if you have problems, for example, in Antarctica, because a lot of the ice shelves are melting. If you talk about pollution, it has an effect across states, mainly because it's no longer possible to say that what happens in a single state in terms of the environment has no effect on other states. So if, for example, if there are forest fires occurring in Indonesia, mainly because of the practice of slash and burn, where a lot of their farmers, and oftentimes this is an illegal activity, when they burn down forests in order to clear land so that they can then engage in farming, the effect of those forest fires is to, pollute the air, and it has an effect on the health conditions of states which are quite close to Indonesia. So there's an effect on Singapore, it's an effect on Malaysia, and other states quite close to Indonesia. It can also affect international air travel because it then poses a problem for airlines. There's also the global issue of humanitarian crisis. And so you've seen the occurrence of a lot of international refugees from war-torn countries such as Syria or Iraq or Libya. And there are also humanitarian crisis going on in parts of Africa, mainly because of the wars that are going on and the problems about illnesses, the problems about lack of food and famine. And obviously, we are aware about human rights violations which go on in a lot of states, which does trigger an effect on other states because they are concerned that what happens in a specific state actually becomes a burden, actually becomes a source of concern for other states. So if there are major human rights violations in other parts of the world, such as the Philippines or perhaps in Mexico, where people are getting killed, it does affect other states. And we typically, as seen through the actions of our Australian government officials, we do tend to react. We do come up with statements, official policies on how we should be responding. There are also rogue states, typical of which is North Korea, which has access to nuclear weapons. And so therefore, in relation to rogue states, for example, how do we deal with them? And we're quite aware of the problem with terrorism or international terrorism, for example, which requires a global response, because what probably happens in Syria has a trickle-down effect in most states, even in Australia. And so in that case, for example, you have a problem because the ones undertaking international terrorism, for example, are not typically the subjects of international law. These are done by individuals or groups such as ISIS or ISIL, and these are not typically subjects of international law. And yet it requires a set of rules that will govern the conduct of terrorism or in terms of how to deal with it. There's also the notion of military adventurism and pandemics, where you might have a disease that begins to affect a lot of nation states, and it requires a coordinated response. So imagine, therefore, the possibility of a very dangerous disease that can be airborne. Somebody is severely sick, whatever that might be, some kind of influenza virus. There is a passenger from Africa, for example, who might be infected with a major disease that has the ability to quickly spread across persons just by, air droplets being passed on from one person to the next. And that requires a global issue, as we have seen in the past. So international law is, as we can see, is quite relevant, particularly today. And so in this lecture podcast, after studying this topic, you should be able to discuss and explain the relevance and importance of international law. You should be able to identify the subjects of international law, distinguish between international law. So when we speak of international law here, we're actually speaking of public international law, which we simply call international law, and how you compare, therefore, international law from private international law. and then for you to be able to explain the nature, the legal basis, as well as the limitations of international law. So let's look at some specific issues which suggests to us that you need a legal regime that will then be able to govern these specific issues. So a crucial example would be wars and armed conflicts, which actually was the reason why the United States, the United Nations was founded. It was founded in response to World War II. And yet we would have thought that after the devastating effects of World War II, and of course we weren't born then, but that led to the deaths of millions of people, particularly, for example, of Jews as a result of the actions of Nazi Germany in committing genocide. But it wasn't just the Jews who suffered deaths. It was also the soldiers, and particularly the civilians, who were obviously affected by the armed conflict as a result of World War II. And yet, wars have not stopped after the Second World War, and they continue even today in a lot of parts of the world, such as Syria and Iraq. And even Australia itself has been drawn into the wars in Syria and Iraq, mainly because we have sent our own soldiers there, either to train some of the combatants to whom we are allied with, or to ensure that there is less adverse impact on civilians. So this is an action that has been undertaken not just by Australia, but by such countries as the United States or the UK or France or Germany. And on the opposing side, you do have Russia. So given the fact that there are armed conflicts going on, what laws govern? And so should the killings of civilians be permitted? Is that permitted under international law? And you've got questions as well of the power, for example, of a foreign state, such as Australia or the US, to be able to enter Syria or Iraq for the purpose of getting involved in these armed conflicts, whether through military action or maybe just for the purpose of providing assistance. But that actually entails entering, or perhaps in a sense, violating the territorial integrity of a sovereign state. So is that permissible? And what exactly are the rules of international law in regard to that? You can also have issues about human rights violations. And for example, for some of you who may remember, there was the so-called Tiananmen Square massacre in 1989, where thousands of civilian protesters were killed as a result of the crackdown by the Chinese government to stop these democratic activities of its citizens. And in that case, if there is a clear violation of certain human rights by a state against its own people, is there an international law rule that governs that conduct? And what about the complaint of some people that Australia may actually be violating certain norms of international law in the way that it treats boat refugees? And in these instances, for example, a lot of these boat refugees have remained in detention. And when we speak of detention, we're speaking of it broadly in the sense that the freedom of movement of some of these refugees have been restricted, and they've remained in certain islands or in certain detention facilities controlled or under the operation of the Australian government. So if they've remained there for years, is there a violation of some norm of international law? And how about the fact that there might be children who are caught and remain in these detention centers? Does that give rise to a violation of some norm of international law? Some of you may have also come across the extrajudicial killings in the Philippines. And it is quite disturbing because today, since President Rodrigo Duterte took office on June 30, more than 3,000 individuals have been killed as part of a state-sponsored policy, allegedly, of stamping out drug addiction and the drug trade. And what Duterte has done, and I speak from some sense of personal identification with what goes on because I am a Filipino. As a result of the state-sponsored policy of trying to stop the drug trade, there is a policy going on that the Philippine police will just kill not just the drug dealers, but even the drug users. So every day, more than 40 individuals are gunned down in the Philippines as a result of this policy. So there is a bloodbath going on in the Philippines. And the question arises as to whether or not, and it's obviously a human rights violation as well, and the question arises as to whether or not there is some form of international liability, criminal liability, on the part of the Philippine president and his government officials who are involved in the policy of the police in killing drug suspects. So when you speak of extrajudicial killing, it means that this is without the warrant of a court. So on the mere suspicion that an individual is either engaged in the drug trade by pushing drugs, whatever drug it might be, whether it's even marijuana or some other drug, a person can be killed by the police. It's sanctioned by the Philippine government. And more importantly, the policy also involves the killing even of drug users. And so imagine, therefore, the kind of bloodbath going on in the Philippines. And Duterte has said that because he is the Philippine president and heads of government are typically immune from suit, he's saying that he is immune from criminal liability. And the question is that true? And yet, if we recall the events after World War II, those who headed Nazi Germany were actually indicted and tried in the Nuremberg trials. Those were part of the Japanese militarist policies in World War II, were also indicted and tried during the Tokyo trials. And a lot of these military officers were sentenced to death. So in other words, there seems to be a law, an international law, which can subject individuals to criminal liability from the viewpoint of public international law. We also have an instance of Julian Assange, the founder of WikiLeaks, where today he continues to be holed up in the Ecuadorian embassy in the UK, in London in particular, and which raises the question that, given the fact that Julian Assange is actually a fugitive from justice, for example, fugitive from justice in Sweden because he has been charged with sex crimes in Sweden, and there is an extradition treaty between the UK and Sweden. So why is it that the UK seems to have failed to comply with its international law obligation under a treaty to hand over Julian Assange to Sweden? And it appears to be a bit more complex than that, because Julian Assange is inside the Ecuadorian embassy within London. So why isn't the UK government, through its police, able to just barge into the Ecuadorian embassy for the purpose of seizing Julian Assange? So perhaps, given the fact that we will remember that the UK is a sovereign state, it has territorial sovereignty of almost everything that occurs within its own territory. So why can't it just why can't UK police just barge into the Ecuadorian embassy? And as we will later on see, there is, in fact, an international law that governs the sanctity of embassies, and which also provides, as we will later on see, immunity from arrests and detention of diplomats based on norms of international law, whether customary international law or particularly treaties. And we get to examine this. And there's also the WTO agreement, the World Trade Organization agreement, and there are humanitarian crises, which I shall not get into at this time because we've spent quite enough time in this introduction. So moving on, we see that there are several international law issues which do require a certain regime of laws, particularly international law, for us to have a sense as to how these issues and the relations between states or other subjects of international law should be governed. And we will begin by, we will continue with this discussion by looking and examining the meaning and concept of international law. Now, international law at one time was called by another name, and that was the law of nations. So the idea was that there are certain laws and rules that governs the conduct of nations, and that is embraced by the idea of a law of nations. And the idea, therefore, is that if you speak of a law of nations, it means that it is a law that governs nations. So, which means that nations or states are the conventional, the traditional, or the usual subjects of international law. And however, that idea of only the state being the subject of international law is quite outdated, mainly because international organizations such as the United Nations, the World Trade Organization, or the International Court of Justice, or even the International Criminal Court of Justice, these organizations do have a legal personality under international law, and they are also the subjects of international law. So international law, therefore, has now become broader to encompass the activities, the rights and obligations, not just of states or nation states, as to be particular, but we simply call them states. So international law also governs the activities, rights, and obligations of international organizations. It actually also applies to certain individuals who may be responsible for acts of genocide, war crimes, or crimes against humanity, as we will closely examine later on. And as I pointed out earlier, even transnational corporations, or what we might typically call multinational corporations. So multinational corporations are those corporations which have operations or activities across across many states. So you can have Google, you can have Microsoft, you can have Apple, Honda, Toyota, Chevron, BP, and so on. So these are multinational corporations, or sometimes called transnational corporations. These corporations, these transnational corporations, under international law, are recognized actually to have certain obligations, but not necessarily rights, as we will examine later on. So when you speak of the international law, therefore, we see that its subjects have now become more expansive, so that it's not just states, but also international organizations, certain individuals, and certain transnational corporations. So how is international law defined? If you look at the 1987 restatement of the law, the third edition of the Foreign Relations Law of the United States, which is a grouping of experts on international law, not just in the United States, but in other parts of the world. They have defined international law to be the rules and principles of general application dealing with the conduct of states and of international organizations and with their relations inter se, as well as with some of the relations with persons, whether natural or juridical. So here we already begin to see that the definition of international law is broader than the notion of the law of nations, and that specific definition already takes into account international organizations as subjects of international law, as well as a recognition that persons, whether natural or juridical, can actually be caught in the conduct of states and of international organizations, and therefore can be legitimate objects and even subjects of international law. Now, Abbas, who is the author of our prescribed textbook for the course, defines international law as a body of rules and principles contained in various sources, including treaties and customs, which the subjects of international law have accepted as binding on them, either in their relations with one another per se, or in those with other juristic or natural persons. So again, if you examine the notion of persons, therefore, both in the definition of the Foreign Relations Law of the United States, it talks of persons, whether natural or juridical. And as we said, therefore, an example of a juristic or juridical person would be a transnational corporation. Now, so going by the definition of Abbas, we can see that there are certain key elements of international laws. It consists of a body of rules and principles. So that is what international law is all about, or is much about. It is about rules and principles, so because it is a law. So if you speak of a law, you speak of a regime that governs the conduct of certain subjects, and that regime therefore becomes an obligatory regime. So people are obliged to follow it because it is a legal regime. Now, international law, or the body of rules and principles pertaining to international law, is contained in various sources, including treaties and customs. It has subjects, which we said are no longer just states, but international organizations, as well as persons, whether juridical or natural. So when we say juridical, for some of you who may not be too familiar with the term, it means that it is not a natural person, not like human beings, but they are institutions which are artificially created and provided a legal personality by law. So these are typically corporations. And a key element of international law is that not only is the body of rules and principles, but this is a body of rules and principles that have been accepted as binding on the subjects of international law. So it has a binding character, as I pointed out. And it governs their relations with one another per se, or in those with other juristic or natural persons. Now, so we have an idea about what public international law is. We've gone through its definition. We've also looked at its key elements. Let's try to make a distinction between public international law, or what we simply call international law, and distinguish it from what is known as private international law. So as we said, public international law essentially regulates the relations and conduct of states and other international subjects. So public international law does not regulate the relations and conduct of individuals in general. It doesn't regulate the relations and conduct of juristic persons in general. So in other words, there is a very limited scope of the application of its laws, because public international law, or we call international law, can only be applied to the relations and conduct of states and other international subjects, such as international organizations and certain persons, whether natural or juridical. On the other hand, private international law regulates the conduct and the relations of individuals or corporations where there is an international character. But more importantly, it is the fact that the law that is applied in these instances, which involves the relations and conduct of individuals or corporations where there is an international character dimension, more importantly, the law that governs is not international law, but actually the domestic or municipal law of a state or of states. So despite the presence of an international character, in the event of a conflict, for example, in the relations and conduct of individuals and or corporations, and we're going to look at the examples in a short while, it is actually the domestic or municipal law of a state that, or of states, that would govern. So when you speak of a domestic or municipal law, we're talking of the laws, for example, of Australia, or of the laws of New Zealand, or the laws of China. So in these cases where what is involved would be individuals or corporations, despite the presence of an international character, it is the domestic or municipal laws of a state that would apply. So we can therefore distinguish international law from private international law on at least two counts. One is that we can look at it in terms of the subjects. So whereas private international law would govern the conduct of private individuals or corporations, when it comes to international law, the subjects would be states and international organizations, as well as certain juristic and natural individuals, which international law considers to be legitimate subjects of certain obligations or of protection. So the second way by which we can distinguish international law from private international law would be the source of law. So because as we said, as far as private international law is concerned, it is the domestic or municipal laws of a state or of states which govern. Whereas if you speak of international law, we're speaking here of the application of international law, which can include treaties, general principles of law recognized by most civilized nations, or international customs. Now, so let's speak of examples of private international law. So you might have a situation, for example, where you have a male Australian, who marries somebody from New Zealand. And so therefore, if you notice, and let's assume that as a result of their marriage, they have got to live somewhere. And you might even say that they live in New Zealand, or they might even decide to live in the UK. And they may even have children. They may even have properties in Hong Kong. So therefore, you will notice that in the example I gave, there are certain international dimensions to it, certain international elements. One pertains to the nationality. So you've got one is an Australian, the other one was a Kiwi. The other international element may relate to their domicile or where they live, which could be either in Australia or New Zealand or the UK. If they have children, there's a question of where the children might be born, and the question is, what's the citizenship that would apply? And what if the child was born in the UK? You've also have the international dimension if they have properties which they acquire abroad, which they may have purchased in China or Korea and so on. So these are international elements. And the question then is, what laws will govern? Certainly it is not international law, but it is going to be the domestic laws of certain states. And in this case, given the fact that there are certain international elements, the question is, would it be Australian law or New Zealand law or UK law or Chinese law or Hong Kong law? Well, Hong Kong obviously is now part of China. Or it could be Korean law that will apply, given the international elements that I've identified. And what it suggests to us, therefore, in this instance is that it raises a question of which law will apply, and it becomes more difficult because oftentimes there is a conflict in the laws of these various states. So for example, in the example I gave, if it was a male Australian who married a male Kiwi, the question is, would that marriage be legal? Okay, because if the marriage is legal, then perhaps there will be certain rights and obligations that will arise. And the question, therefore, is what law should be applied to determine the validity of such same-sex marriage? In Australia, we don't recognize the validity of same-sex marriages. However, same-sex marriages are valid in New Zealand. So is that marriage, for example, is that valid? So there is a conflict of law between Australian law and New Zealand law. There can also be conflicts in terms of what laws will govern as far as property relations are concerned. Will it be, for example, if the marriage is considered valid, will the principle of an absolute community of property govern, so that the partners own whatever property is acquired during the marriage or even prior to the marriage? Will that be owned in common? Or will it be according to the amount of contributions of each individual? And we will notice that in several jurisdictions, their laws are not the same. There is a conflict of law. If you talk about citizenship, assuming that there had been children, of course, you can't have natural children when it comes to both partners being males. But if both were female, and there was, the possibility of an artificial insemination, so a child would have been born, what is the citizenship of the child? And what if the child was born and in private international law, what is known as jus sanguinis versus jus soli. So jus sanguinis, for example, it means that any child born of a parent, the citizenship of the child will follow the citizenship of the parent based on blood. So that's jus sanguinis. Jus soli, such as the one observed in the United States, is that citizenship is dependent on the place of birth. So we will see that that laws across states are hardly ever the same. So there is a conflict of laws, which means, therefore, that sometimes private international law has been known also as the conflict of laws. Now, the notion of conflict of laws as being synonymous or the same as private international law is, in a sense, misleading and has been questioned by some authors, mainly because it focuses on the conflict of laws as private international law. In fact, when you look at conflict of laws, the focus of conflict of laws as a set of rules is not so much the conflict, but actually the resolution of the conflict. So that the goal of any forum or any court of a forum, meaning of a specific state, its goal is always to try to find a way to reconcile certain laws and to determine what is the most legal and the most equitable law that should be applied in a certain situation. So the focus is not so much in conflict of laws, therefore, in truth, the focus is not so much on the conflict, but the resolution of the conflict. Now, moving on, earlier we talked about international law as a source of obligations that is binding on states. But the question is, how does a state become bound by international law? And if you look at the presence of treaties, obviously, if you speak of a treaty or an international instrument between states, it means that for a state, for example, to enter into a treaty, the state will have consented to the treaty. So therefore, clearly we see that in that instance, the treaty as a source of international law or a source of international obligations of a state. It is based on the consent of a party state, which leads to the question of whether or not consent is the only basis of international law. Now, we will recall that after World War II, there was the Tokyo trial and the Nuremberg trial of military officers who were accused of war crimes and of genocide. It was obvious that these military officers did not consent, and in fact, vehemently questioned the jurisdiction of these war tribunals. They did not give their consent, and yet, notwithstanding the absence of consent of these individuals or even of the respective states, these individuals were indicted and tried under international law. So what we do know now is that there are certain peremptory norms of general international law, such as the non-commission of genocide or slavery, which are prohibited. And it is not permissible for any state to opt out of these peremptory norms of general international law. So in that case, therefore, states and certain individuals, including transnational corporations, can be the subject of obligations under international law, even in the absence of their consent, or even despite the insistence that they do not consent. Apart from the notion of a peremptory norm of international law, which I'd like to go back to the definition of the 1969 Vienna Convention on the Law of Treaties. Under Article 53, the Vienna Convention on the Law of Treaties defines a peremptory norm of general international law as a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted, and which can only be modified by a subsequent norm of general international law having the same character. And in fact, under Article 53 of the Vienna Convention on the Law of Treaties, it is not even permissible for a state to enter into a treaty that derogates from a peremptory norm of international law, which gives us some sense of the nature of international law. On the one hand, it is positivist in the sense that laws become laws only because states agree that they are law. So the binding character of a law is according to the positive action or acquiescence of certain states. So in other words, if a state does not agree to be bound, then a certain rule does not become law. That is part of positivism. And yet, we now know that there are certain rules and norms of conduct which are binding on states and other subjects of international law, notwithstanding the absence of consent. Which brings us the idea, therefore, of naturalism, that there are certain rules and certain norms which are so important and fundamental that they command the respect and observance of states regardless of their non-consent. Now, apart from the notion of the peremptory norm of international law, which is binding upon all states and subjects of international law, notwithstanding the absence of consent, you also have general rules of customary international law that can be binding on a state, notwithstanding its lack of consent. An example is the principle of state immunity. And the principle of state immunity essentially means that a state cannot, without its consent, be subject to the laws of another state. So, Australia, for example, cannot become the subject of a law of New Zealand or of the UK or of China. So the UK, so if somebody in the UK, for example, tries to sue the Australian government in the UK for whatever reason, let's say for the violation of the rights of both refugees, or because the Australian government entered into a contract with a corporation. And that contract was actually according to the sovereign character of Australia. So it could have related to its defense power. So therefore, the character of the contract is not commercial, it's actually sovereign. The question is, if Australia reneges on its obligation under the contract, can it be sued by somebody in the UK? And assuming that the contract was signed in the UK, can it be sued in the courts of the UK? The answer is no, because of the principle of state immunity. And what it suggests is that it is not permissible for a state to just say that I have not agreed to the principle of state immunity. Therefore, it is permissible for me to make another state bound under my own laws because they operated within my state. That won't be allowed under the rules of international law, because in that case, state immunity as a customary international law, as part of customary international law, binds all states. So it's no longer just the subject of a treaty obligation. It is part of customary international law, long immemorial, prior to the ability of states to enter into treaties. So that has always been a practice that has been observed by most states, that there is a principle of state immunity. And yet, despite the idea that in general, the ability of a state to be bound by international law is based on consent, and so that to a great extent, the binding character, it is only in very exceptional circumstances that that states can be bound, notwithstanding the absence of consent. We go to the question of the wars and the humanitarian crisis going on in other parts of the world, whether it's in Syria, Iraq, or Afghanistan, where certain states, Western states in particular, whether it's the UK, Germany, or France, the United States, and Australia, and New Zealand, they have gotten involved in these military conflicts against the wishes of a state. So for example, Bashir Assad is against the involvement of the Western states in the conflict within Syria. And in the case of Afghanistan, when the United States went after the Taliban regime, which was then the governing, the legitimate government in Afghanistan at that time, they bombed Afghanistan and sought to kill or arrest a lot of these Taliban leaders who were at that time trying to harbor Osama bin Laden. And so in that instance, how can the intervention of Western states be justified on the basis of international law if a sovereign state refuses to permit these foreign states from entering its territory? And there is a very important general customary rule of international law known as territorial sovereignty. So that it would be a violation of international law, for example, for a foreign state to invade the territory of another state. And when I speak of invasion, I speak of it broadly, not just military invasion, for example, but intervening in the affairs of another state. So in the case of Syria, Iraq, and Afghanistan, how can that be justified under public international law? And so these are the questions that we will continue to examine in greater detail as we move on throughout the term. Now, one of the things that we need to observe is that unlike municipal law, or in most municipal law systems or states, you typically have three branches of government. So you have the executive, who can be the president or who can be the prime minister. You have the parliament or legislative body, which can, in the case of Australia, be the Australian Commonwealth Parliament. And then you have the judiciary. So you have the three branches of government. And in municipal law, we know that the federal parliament has the supreme power to pass laws that are binding on all Australian subjects. And to an extent, even the executive, whether it's a prime minister or a member of the cabinet or some other agency of the executive government, to an extent, they may also pass legislation binding on Australian subjects on the basis of what is known as subordinate legislation or delegated legislation, delegated legislative authority coming from the Commonwealth Parliament. So we have in municipal law government agencies or government branches that have the power to make law that is binding on its subjects. We don't have that equivalent in international law. So there is no world parliament or legislature that creates laws that are binding on states. The United Nations does not have the power to pass a law that becomes binding on states. It has to be states inter se, or states among themselves, making law, for example, by entering into a treaty. But the United Nations is not a world parliament, or it is not a legislature that creates laws binding on states. And except, for example, for peremptory norms of general international law, it is therefore states themselves that make international law. But even then, when you look at the notion of the peremptory norm of general international law, those norms became peremptory norms mainly because either of state action or state practice. So again, it is states themselves that made international law. In addition, there is no world court that has compulsory jurisdiction over all states. So assuming that there was a conflict between two states, you don't have a world court that has compulsory jurisdiction over all states. So not even the International Court of Justice has compulsory jurisdiction over all states, as we will examine more clearly later on. There are also severe constraints in the enforcement of international law decisions, such as decisions eventually given by the International Court of Justice, for example, or the International Criminal Court of Justice, because the enforcement of its decisions ultimately will rely on the voluntary compliance of a state. So even if there were a decision handed down by the International Court of Justice, for example, against the United States or against Australia, there is no way that the International Court of Justice can enforce its obligations against the United States or Australia on its own. It will have to rely on Australia and the United States in these examples to comply with a decision of the International Court of Justice, which is not the same in a municipal system, because decisions of a domestic court, such as the Federal Circuit Court or the Federal Court of Australia or the High Court, can be enforced through the mechanisms and the agencies of Australia itself. In international law, you also don't have a world president or prime minister who is the recognized ruler of the world. You don't have that. So even the president of the United States, whoever he may be, even if he is even if the United States may be considered to be the superpower of the world or the number one honcho in the international legal order, the president of the United States cannot decide for what the rest of the world should do. His actions may obviously have an impact on other states, but he is not the recognized ruler of the world. So there is no world president or world prime minister. Which leads us to certain questions. How then is international law able to function and function effectively. And as we have kind of observed, international law is able to function and function effectively because it relies on the cooperation of states. In other words, states realize that the world is a better place and that the world is better off if they cooperate with each other and that they allow themselves to be bound by international law, because it leads to a more predictable, a more peaceful and secure world for international legal order if everyone tries to observe international law. We do know that the reality of it all is that there are some states, the more powerful ones, such as the United States, Russia, and China, which at times can choose to ignore international law. And they've done it multiple times. And again, it brings to the question of enforcement, because although we might say that international law is binding on states as far as the enforcement of certain obligations or the enforcement of certain decisions that may be handed down, for example, by the International Court of Justice, the enforcement of those decisions will rely on the cooperation or the voluntary compliance of a state that is involved. So this tells us that despite the sovereign equality of states, there are in fact some states that are more equal than others, and they command more power in international law, which means that, for example, the United States decided on its own, for example, to invade Libya and oust Muammar Gaddafi. It also chose to invade Afghanistan to remove the Taliban regime by, with the United States deciding on its own, regardless of what the rest of the international community said. So after studying this topic, you should then be able to discuss and explain the relevance and importance of international law, identify the subjects of international law, distinguish international law from private international law, and explain the nature, legal basis, and limitations of international law.